All right, when you're ready, just proceed.
Good afternoon, my Lord. My name is Gordon Watson, and I appear today on behalf of the Procure. This case concerns a dispute regarding the hiring of a web optimization service by the Procure from the defenders. I submit to your Lordship that the defenders did not provide the Procure with a service which conformed to the terms of the contract as agreed between the parties, and that the defenders were accordingly in breach of the contract with the Procure.
Right.
In order to succeed, I must satisfy your Lordship that the defenders were in material breach of their contract with the Procure in the circumstances of the particular case. I will be moving.
Can you just slow down a little, Mr. Watson? I'm trying to note this down, and it's hard to note it down when you're speaking at that pace, okay? So you're saying that they were in material breach?
Material breach for a contract, that's right.
Yeah, all right. Thank you.
I will be moving your Lordship to grant a decree for the sum of £1,200 that the Procure has dispensed with to date, and with fulfilling his obligation to do that.
Right.
In the course of my submission, I shall detail 3 possible avenues that your Lordship may choose from, all of which entitle the Procure to the specified financial remuneration.
Right.
The facts of the case, I might assist your Lordship if I were to summarise the crucial facts in this case. The facts are as follows. The Procure is a self-employed individual running his own business as a joiner and cabinet maker. The defenders specialise in online advertising for client products. In December of 2011, the Procure received an email from the defenders' company making a special offer in relation to web marketing services. The Procure struggled to sell his handcrafted furniture through his own website. So he spoke with a salesperson for the defenders' company named Kate via telephone, and she discussed the email with the Procure. Kate advised that the defenders' web optimization service would send the Procure, quote, dozens more customers per month, end quote, and increase the sales by 25%.
Right, can you give me a second? I just want to get that jotted down.
Sure.
So Kate said, and you're putting this effectively in quotes, that this service that they provided would send them dozens more customers per...
I'm not sure the last 2 words are verbatim.
Right. Dozens more customers.
Dozens more customers.
Okay. And what was the other thing that she said?
She also advised that the Procure would receive an approximate 25% increase in turnover as a result of entering into the agreement with the defenders.
And can you help me with this? Did she actually say this will provide you with an increase in turnover?
She said that she expected that this would, and the difference I will scrape to your Lordship later on in my submission and why I believe this is relevant. But I should just proceed to detail the rest of the facts as they are. She confirmed the salesperson Kate the special offer of £200 per month with a minimum commitment of 1 year. Kate stated the special offer was only valid for that day. The Procure agreed to the offer by telephone. He then proceeded to set up a bank transfer and monthly direct debit. Kate also promised the Procure written contract that he never received.
Can I stop you at that, Mr. Watson? Just want to be clear at this point. You say that she promised him a written contract that he never received. For the purposes of your submission to me, does the fact that she promised him a written contract that was never sent, does that have any significance? Should I take that into account?
It doesn't have any direct significance to either of my 3 submissions just to follow.
That's fine. Just want to be clear with that. That's fine.
The Procure discovered, or rather, after 6 months, the Procure earned averaged £1,500 per month, which was his approximate earnings before entering into the agreement. The Procure discovered that the defenders had relied on Google AdWords to provide for the service. The pursuer discovered also that he could utilise this service without contracting with the defenders at a cost of around £100 per month, which is approximately half of what he was already paying to the defenders.
Mm-hmm.
Crucially, at no point was there a mutual contractual agreement to assign a subcontract. The pursuer cancelled the direct debits, and the defenders refused to reimburse the £1,200 that the pursuer had paid for the first 6 months.
Mm-hmm.
I'll now proceed to the legal basis of my argument.
Yeah.
I submit to your lordship that the defenders were in material breach of contract in the following 3 respects, and I will detail my first submission.
Yeah.
In terms of the defenders subcontracting with Google AdWords, this was done without the pursuer's consent, and therefore constitutes a breach of contract. The general terms and conditions of contract of Scots law, which can be accessed section C1.1 of the report at www.hermajestyrevenueandcustoms.gov.uk, specifies the contractor shall not assign or subcontract any portion of the contract without the prior written consent of the client.
Sorry, what are you referring me to? You mentioned HMRC. Is this a case or what?
No, this is the explanation of the laws provided on the HMRC.
Oh, right. I'm sorry, I didn't catch that. All right.
It's effectively a rule book for what can and cannot be done in contractual agreements under Scots law.
Yeah.
It continues to say, subcontracting any part of the contract shall not relieve the contractor of any obligation or duty attributable to the contractor under the contract or these conditions.
Right.
This is also provided for the basis that one cannot subcontract without the written consent of both parties can also be found in case law under the case of James Scott Limited against Apollo 2000 FC 228. Now, my lord, I have to note that any reference I make to case law is only in terms of summarising the ratio of the case. I do not make any specific reference to quotations or...
That's right. Well, that's okay, that's acceptable to me, Mr. Watson.
I will now proceed to my second submission. In terms of the service as described by the salesperson Kate to the pursuer during that telephone conversation, just prior to the contractual agreement, there was a breach of the implied term to provide the service as described. Section 11I of the Supply of Goods and Services Act of 1982 provides the following. This section applies where under a contract for the hire of goods, the supplier hires or agrees to hire goods by prescription. In such a case, there is an implied term that the goods will correspond to description.
Can you help me with something, Mr. Watson? This section talks about a contract for the hire of goods. What do you say in this case was being hired?
The agreement was to effectively hire a service, to utilise a service, not indefinitely, but for a specified period of 1 year. Right. Now, before the agreement or after the 1 year, presumably there would be no more utilisation of the service.
Do you think that's a hire? I know what hiring a car is, for example. Do you think what you're describing is a hire of a service? I
believe it is a hire, and in the present cases it's a hire. In your lordship's example of a car, that would fall under a different category of hire purchase agreements, which constitutes a different area of the law. But no, you could just go and hire a car to drive up north next week if you want. You don't need to hire purchase it. No, of course. You know what I mean? Of course, your lordship does have the advantage of it there, but I submit to your lordship nonetheless that I believe the purposes of the present argument, there is an effective hiring of service, and the wording that one might choose it may differ on that aspect.
Okay.
I must also submit to the Lord that for the purposes of this Act, the Supply of Goods and Services Act includes to goods refers to both goods or services or both.
Yeah. All right.
There is a breach of the implied term to provide the service as described, insofar as the pursuer did not receive any increase in turnover and the service was not the vendor's own web optimization service that they had advertised and that they had discussed in the pre-contractual telephone conversation. In fact, the service was produced by the third party Google through their own web optimization service AdWords.
Mm-hmm.
Therefore, the defenders having breached the implied term of law to provide the service as described to the pursuer. Furthermore, page 113 of Joe Thompson's contract law in Scotland states that terms implied in law are included in the contract unless both parties agree otherwise.
Right.
My third and final submission, my Lord, it comes in two parts. The first part is actually a delictual remedy, which can be found for damages that I will explain briefly.
Yeah.
In terms of case states the pursuer that he would likely receive a 25% increase in revenue by entering into the contractual agreement with the defenders. This constitutes a negligent misrepresentation inducing the pursuer to contract. There are two remedies in law for such an instance. The first, as I say, is a delictual remedy, which can be found under Section 10, Part 1 of the Law Reform Miscellaneous Provisions Scotland Act of 1985, which provides a party to a contract who has been induced to enter into it by negligent misrepresentation made by or on behalf of another party to the contract shall not be disentitled by reason only that the misrepresentation is not fraudulent from recovering damages from the other party in respect of any loss or damage he has suffered as a result of the misrepresentation. And any rule of law that such damages cannot be recovered unless fraud is proved shall cease to have effect.
Right.
Effectively, what this legislation is providing, my Lord, is that one does not have to prove that vendors were fraudulent, that they had dolus malice and malicious intent.
Yeah.
One needs to only prove that Kate's misrepresentation was negligent and that it was done to induce the pursuer to enter contract, which I believe is a reasonable assertion given that the negotiations with telephone were immediately before a contractual agreement was made.
So the representation that Kate made, which you're talking about, I hadn't noted, that's why I really asked you earlier on. There's two parts to that. First is that this would send them dozens more customers.
Certainly.
Now, did it?
The difference, my Lord, is that the Kate had said that the defenders had said they would expect their web optimization service to send dozens more customers, and that was the case. This is not a dispute.
So they did get dozens more customers.
He did receive dozens more customers.
So that representation comes out to be correct.
Certainly that representation, I would not dispute that turned out to be correct, my Lord.
Right.
However, Kate's own representation to the client in her capacity as a salesperson, obviously whose job is to try and persuade the pursuer to enter into contractual agreement. Her own representation was negligent in saying that she expected a 25% increase in turnover, which is obviously a very significant financial increase in what the pursuer would otherwise expect, and certainly induced him to enter into the agreement with the defenders.
So it's that aspect of the representation that you are focusing on, is that correct?
That's correct, my Lord. It's very specifically the fact that Kate, as her capacity as a salesperson, represented to the pursuer that he would receive a 25% increase in turnover.
All right.
And I submit that that is negligent and because of her professional capacity to try and encourage a contract. Now, the second part of my third and final submission concerns the contractual law and that the contract can be voidable as a result of this negligent misrepresentation.
Yeah.
Now, a statement of opinion is not a valid warranty. However, a negligent misrepresentation that induced the procurer, I would say, to enter into the agreement can have the effect of having the contract rescinded, since it was reasonable for the procurer to rely on the statement.
Mm-hmm.
This was provided for in the case of Esso Petroleum Company Limited against Martin Limited, 1976.
Mm-hmm.
Citation is QB 801.
Yes.
A statement as to earning potential was deemed contractual warranty in this case, and therefore award damages for contractual breach covered the full cost of the plaintiff's inducement to enter that contract.
Mm-hmm. So that's very much you've got here, in a sense, isn't it? That your client is persuaded to enter into the contract because he's been told that there's an earning potential from this facility that the defendant will provide.
Certainly, my Lord. Absolutely, the case is that without this representation that he would receive a 25% turnover, there was no reason or motivation to enter into the agreement.
All right.
He was effectively making an investment on the representation that he would receive even more money.
All right.
And obviously, the present instances do not cover innocent misrepresentation, but I submit to your Lordship that it is not reasonable to consider a case in her capacity of a salesperson and a professional making a statement so proximate to the conclusion of that agreement to have made an innocent misrepresentation. In addition, the case of Stewart against Kennedy, 1890, 17RHL 25, stipulated that in order for a negligent misrepresentation to be constituted, the guilty party's misrepresentation must cause the innocent party to enter into the agreement by way of error.
Mm-hmm.
And it was this case, the reason I cite this case, my Lord, is this was the case that introduced this principle into Scots case law. It is my submission that if any of these breaches have been established, then the procurer is entitled to termination of future obligations and financial remuneration to the amount of £1,200.
Right, okay.
Now,
That's right, Mr. Watson. I think we'll stop you there. I can see you've given me your written submissions to conclusion, and really you're just summarising the arguments that you put before in your conclusion.
I was just going through it.
Well, that's fine. I'm quite happy with that so far. So thank you very much indeed.
Thank you.
Thank you.